Guide to Understanding U.S. Immigration Statutes, Constitutional Authority, and Enforcement, Separate from Politics and Opinion. Let's explore what the law actually says about immigration in the United States. Immigration debates are often emotional, clouding factual understanding of federal law. The law is rarely explained, leaving Americans unclear on the rules. Policy arguments frequently fail without legal clarity, making productive reform debates challenging. Federal immigration law consists of statutes passed by Congress, which are binding legal rules. Politics involves enforcement choices, but cannot rewrite these statutes. Conflating law with enforcement obscures accountability, highlighting the difference between legal boundaries and political decisions. Congress writes the law, setting visa quotas and grounds for removal. The executive branch enforces these laws, while courts interpret disputes, ensuring actions comply with statutory authority. Each branch plays a distinct role in immigration control. The Constitution grants Congress the power to regulate immigration, while the President enforces federal law within statutory boundaries. Federal courts adjudicate immigration disputes, safeguarding constitutional rights in removal proceedings. No branch overrides another in immigration matters. Each exercises independent authority, with enforcement agencies having discretion in resource application. Courts interpret and apply the law, but do not legislate or rewrite statutes. Immigration regulation is exclusively federal, with states unable to enact conflicting schemes or grant lawful status. Only federal law and agencies control admission, emphasizing the supremacy of national authority in immigration matters. States can cooperate with federal agencies, share information, and enforce non-conflicting laws. They assist in immigration enforcement efforts, provided actions do not conflict with federal law, highlighting their supportive role in the immigration system. Federal law defines four primary categories of immigration status: U.S. citizens, lawful permanent residents, unauthorized aliens, and lawful non-immigrants. Each category has distinct rights, obligations, and legal protections, shaping the immigration landscape. U.S. citizens enjoy full constitutional rights, including voting and federal benefits. Citizenship is acquired by birth or naturalization and cannot be revoked except in rare cases of fraud. Deportation does not apply to citizens, ensuring their legal security. Lawful permanent residents, or green card holders, are authorized to live and work indefinitely in the U.S. However, they can be deported for certain crimes, with federal law defining specific deportable offenses, balancing rights with responsibilities. Non-immigrants enter the U.S. on temporary visas for specific purposes like tourism, study, or work. Admission depends on meeting visa requirements and maintaining lawful status, with overstaying or violating terms resulting in loss of legal status. Unauthorized presence occurs when an individual is in the U.S. without legal immigration status. Entry without inspection, visa overstays, and civil violations contribute to unlawful presence, handled through immigration court rather than federal crime. U.S. law separates civil and criminal violations in immigration. Civil cases are heard in administrative courts, while criminal cases go through federal district courts. Each has distinct procedures and consequences, emphasizing the legal distinction. Unlawful presence, status violations, and immigration court proceedings are civil immigration violations. These are adjudicated by immigration judges, triggering civil consequences rather than criminal penalties, focusing on legal compliance. Civil penalties for immigration violations include removal, detention, fines, and re-entry bars. Deportation is the primary penalty, with monetary fines and statutory bars affecting individuals' future re-entry, emphasizing the consequences of civil violations. Illegal re-entry, smuggling, and fraud are federal crimes with significant prison terms. These criminal immigration violations are prosecuted as federal offenses, highlighting the serious legal consequences of unauthorized actions. Federal prosecution, prison sentences, and criminal fines are penalties for criminal immigration violations. These differ from civil penalties, with substantial fines and imprisonment emphasizing the severity of criminal offenses in immigration law. Federal immigration law grants enforcement agencies powers to carry out statutory mandates. Customs and Border Protection, ICE, and immigration judges play roles in inspections, detention, and removal orders, ensuring compliance with immigration statutes. Federal law mandates enforcement of immigration statutes, with discretion not erasing legal status. Unauthorized presence remains unlawful, even if not actively prosecuted, underscoring the non-optional nature of enforcement in immigration law. Executive discretion involves agencies evaluating individual circumstances when deciding whether to initiate removal proceedings, grant relief, or defer action. This discretion is applied on a case-by-case basis, focusing on individual cases rather than categorical claims. Additionally, limited enforcement resources require prioritization, with agencies focusing on threats to public safety and national security. However, these priorities do not eliminate statutory grounds for removal. While prosecutorial discretion allows deferring individual cases, executive agencies cannot override statutory requirements or eliminate congressionally mandated visa caps and status categories. Only Congress has the power to create immigration statuses and authorize work permits. The executive branch's discretion does not include the power to grant lawful status or legal residence. The Immigration and Nationality Act provides individuals the opportunity to apply for asylum if they have suffered persecution or fear future persecution in their home country. Asylum claims are decided on a case-by-case basis, where applicants must demonstrate eligibility through evidence and testimony before an immigration judge or asylum officer. To meet asylum requirements, applicants must establish a credible fear of persecution or torture if returned to their home country, which is the initial screening standard. Persecution must be based on race, religion, nationality, political opinion, or membership in a particular social group. Economic hardship alone does not qualify as a protected ground. Refugees seek protection from outside the United States, usually through UNHCR referral and U.S. resettlement programs administered by the State Department. In contrast, asylum seekers apply at or after arrival in the U.S. The processes, timelines, and adjudicating bodies differ significantly between refugee and asylum pathways. The Constitution mandates that individuals in removal proceedings receive certain procedural protections. The government must provide clear written notice of the immigration violations alleged and the legal basis for removal proceedings. Individuals have the right to appear before an immigration judge, present evidence, and challenge the government's case for removal. Respondents may submit documentary evidence, call witnesses, and testify on their own behalf, with the burden of proof lying with the government in removal cases. Immigration proceedings are civil administrative hearings, not criminal trials, and there is no constitutional right to a jury in removal cases. While individuals may hire private attorneys, the government does not provide free legal representation in immigration court, unlike criminal proceedings. Federal law does not suggest that border enforcement is discretionary. Statutes explicitly authorize inspection, exclusion, and removal of individuals without legal status. Additionally, physical presence in the United States does not confer legal status or a pathway to citizenship. Federal law requires specific procedures and eligibility criteria for naturalization. The Immigration and Nationality Act, as amended, governs present-day enforcement, and agencies must implement existing statutes regardless of policy preferences. Reforming immigration law requires new legislation passed by Congress and signed by the President. Executive action cannot substitute for statutory amendments. Closing thoughts emphasize that understanding statutes, constitutional authority, and legal structure is essential to informed debate. Separating legal requirements from political preferences enables honest policy conversations. Productive change